Small tax court cases, called S cases, are the simpler and faster lane in tax court. The trade-off is brutal. The decision is final. No appeal for you, and no appeal for the IRS either. On the EA exam, they love asking you to spot that one key feature. S case equals speed and informality, but you give up appellate rights. To use small case procedure, the taxpayer has to request it, and the tax court has to accept it. Practically, if you qualify, the court usually goes along. Another exam favorite, S-case decisions are not precedent. They're generally not published and don't control other taxpayers' cases. So you're resolving your dispute, not making new law. Regular tax court cases are different. Either side can appeal a regular tax court decision to a U.S. Court of Appeals. That's why the S-case choice is strategic. If the issue is close, or you care about preserving appeal rights, a regular case may be worth the extra formality. If you just want a faster, lower-stakes resolution, S-case can be a great fit. Now, contrast tax court with refund litigation. If you go to U.S. District Court or the Court of Federal Claims, you generally must pay the tax first, then sue for a refund. That's the big difference. Tax court is usually prepay, while refund courts are pay first. On the exam, if you see district court or federal claims, your brain should immediately say, pay first, then refund suit. Why would someone choose district court or the Court of Federal Claims? Sometimes they want a different forum, or they believe case law in that venue is more favorable, but they must be able to fund the pay first requirement. Also, decisions from these trial courts can be appealed up the chain, unlike an S case. So you're trading cash up front for a different court path. One more trap: representation. Enrolled agents and CPAs have unlimited representation rights before the IRS, including appeals. But in federal courts like U.S. District Court, Bankruptcy Court, Courts of Appeal, and the Supreme Court, representation is generally limited to licensed attorneys. So if the question asks who can represent a taxpayer in district court, the safe answer is an attorney, not an EA. Marcus was audited and went all the way to U.S. tax court. He won. He paid a lawyer to file the petition and also paid court filing fees. The question is, can Marcus recover the legal expenses he incurred to defend his position? The choices range from yes, but only if certain requirements are met, to no reimbursement at all. Think about it. The best answer is yes, but only if the requirements are met, meaning he's the prevailing party and the IRS position wasn't substantially justified, plus other statutory limits. That's why the only if the court agrees on most issues and finds the IRS unjustified option is the closest match. A tempting wrong answer is that only filing fees might be reimbursed, but litigation costs can include attorney's fees when you qualify. A case in the U.S. tax court is commenced by what action? The options include an IRS impasse, a formal protest, the filing of a petition, or a taxpayer's appeal. This is testing the exact trigger that starts the tax court case. Think about it. The correct answer is the filing of a petition. A tax court case officially starts when the taxpayer files a petition with the tax court, typically after a notice of deficiency and within the deadline. A formal protest is part of IRS appeals, not what commences a tax court case, so that option is a common distractor.